Welcome back, CA Foundation students. स्वागत है दोस्तों. I know contract law can sometimes feel like a never-ending maze of heavy legal jargon, but get ready because today we are going to completely demystify one of the most absolutely crucial units in this chapter. We are talking about the concept of consideration. If you want to clear your exams, इसको समझना बहुत ज़रूरी है भाई लोग. This is literally the core of how contracts actually work in the real world. So grab your notebooks, get comfortable, and let's get started.
Okay, let's dive right in with a quick question. Tell me honestly, क्या बिना एक रुपया दिए आप legal contract बना सकते हो? Think about it for a second. If I promise to just give you my car, and you don't give me anything in return, is that a valid contract? Like, can I be dragged to court if I simply change my mind tomorrow? Well, the short answer is usually no. The law requires a give and take. For a promise to be legally enforceable, there absolutely must be some sort of exchange happening between the parties. You can't just get something for nothing in the eyes of the law.
And this brilliantly illustrates our first major concept. The Latin buzzword you absolutely need to memorize for the exam is quid pro quo. तो दोस्तों, इसका सीधा मतलब है कुछ के बदले कुछ. This is the absolute heart of consideration. The law basically says, if you are making a promise, what price is being paid for it? That price, that return value is your consideration. बिना इसके, your promise सिर्फ एक हवा-हवाई बात है. It's just a friendly statement, not a binding legal obligation that a judge is going to enforce.
So, here's our game plan for today. We'll start by breaking down the concept of quid pro quo, then we'll unlock the golden rules of consideration. After that, we're going to tackle the doctrine of privity, look at some sneaky contract rule breakers, and finally, wrap it all up with a quick exam recap.
All right, let's kick things off with the official legal definition right out of the Indian Contract Act.
Section 2D says, when at the desire of the promiser, the promisee, or any other person has done or abstained from doing something. Now, I want to draw your attention to that specific word, abstained. Consideration isn't just doing a physical act like paying money or delivering goods. It can also be abstinence. मतलब कुछ ना करने का promise. For example, agar Abhishek promises that he won't file a court case against Bharti if she pays him 1 lakh rupees. Here, Abhishek's abstinence, holding back from suing, is completely valid consideration. Dhyan dena, this idea of forbearance to sue is a very popular concept they love to test.
To understand this even deeper, you've got to mark the landmark English case Misa v. Curry in your notes. This case established that consideration has a double aspect. It's either a right or profit accruing to one party, madlab ek ka fayda, or some detriment, loss, or responsibility suffered by the other party, matlab dusre ka nuksan. So you see, consideration is always a two-way street of benefits and detriments. One person is gaining a legal right, while the other is taking on a legal burden.
Moving right along, let's look at the actual rules of the game.
Think of these as your ultimate cheat codes for solving those tricky problem questions. The examiners love to test these. First up, consideration must move at the desire of the promisor. आप अपनी मर्जी से कुछ करके पैसे नहीं मांग सकते. The other person actually has to ask for it. Second, it can move from the promisor or literally any other person. Third, and this is different from English law, Indian law fully recognizes past consideration, as long as it was driven by a previous request. Fourth, it doesn't need to be adequate. Fifth, it must be real, meaning not physically impossible. And finally, of course, it absolutely must be lawful. No illegal acts allowed, obviously.
Let's actually zoom in on that second rule for a second, because this is a massive VIP exam tip specifically for the Indian context. Consideration can move from any other person. This means a stranger to consideration is perfectly valid under the Indian Contract Act, even if the person receiving the promise didn't pay for it themselves. As long as someone provided the consideration, the contract stands. This is exactly where ICAI exam problem questions will try to trick you, so keep this concept crystal clear in your head.
And this brilliantly illustrates our next landmark case, Chennaya versus Ramaiah from 1882. Guys, ek must family drama hai ye. Listen closely. An old lady gifted her property to her daughter, but with a strict condition to pay an annuity to the maternal uncle, the Mamaji. The daughter agreed and signed a document with her uncle. But later, she flat out refused to pay, arguing, Mamaji ne mujhe kya diya? She said he gave her no consideration. But the court held that the consideration had already moved from the old lady when she originally gifted the property. So the uncle, even though he was a total stranger to the consideration, won the case.
Now let's quickly clarify rules 4 and 5, inadequate versus illusory consideration. एग्जाम में यही फंसाते हैं. The law simply does not care if you made a bad deal. If you freely consent to sell your brand new 50,000 rupee phone for just 5,000 rupees, that is inadequate. But it's totally valid. आपका नुकसान law को कोई मतलब नहीं, as long as nobody forced you into it. However, illusory consideration is completely invalid. If I promise to pay you 10,000 rupees to bring a dead person back to life, well, unless you have magical powers, that's physically impossible. The consideration isn't real, so the contract is void right from the start.
Now brace yourselves for a pretty massive plot twist.
While we literally just learned that a stranger to consideration is perfectly fine, the rules change drastically for a stranger to a contract. यह difference exam में पक्का आएगा, ध्यान से समझना. A stranger to the contract, meaning someone who didn't actually sign the agreement, generally cannot sue to enforce it. Why? Because contracts are inherently private relationships. This strict rule is known as the doctrine of privity of contract. Only the actual parties involved have the right to take it to court to protect themselves from random outsiders interfering in their business.
But, like everything in law, there are always exceptions where a third party actually can sue, which brings some much-needed relief to this strict doctrine. For instance, if a trust is created for your specific benefit, you up sukar sakte ho, even if you didn't sign the original trust document. The court will step in to protect your beneficial rights. The exact same thing applies to members in a written family settlement where provisions are made for specific people. They can enforce it. It also applies to an assignee who has legally received the benefits of a contract or in situations involving covenants running with the land.
All right, let's move on to some of my favorite scenarios, the ultimate rule breakers.
So the general rule we've been hammering home is no consideration, no contract. But how can a contract exist without any give and take? Bina consideration ke contract, ye la kaise allow karta hai? Well, Section 25 outlines some very specific, kind of magical scenarios where an agreement without consideration is totally valid and legally enforceable. These are instances where the law recognizes other powerful motivations, things like natural love, duty, or charity, that completely override the strict need for a commercial exchange.
Here are the top 3 rule breakers you need to know. Number 1. Completed gifts. If you actually hand over a physical gift to someone, you can't come back a week later and demand it back, crying that there was no consideration. The transaction is done. Number 2. Bailment under Section 148. Think about giving your Activa to a mechanic for repair, or just handing your laptop to a friend to use for the weekend. That delivery of goods is bailment, and absolutely no consideration is required to make that handover legally valid. And number 3.
Okay, we've covered a lot of ground. Time to test what you've learned. Let's say you promise to donate a large sum of money to a charity, but you get absolutely nothing in return. Can they legally sue you if you suddenly back out? The answer actually lies in the famous case of Kedarnath v. Gauri Muhammad. The general rule is, a mere promise to donate is not binding because there's no consideration. But, and this is a huge but, if the charity undertook a specific liability or, say, started construction based on your promise, then yes, they absolutely can sue you, because your promise caused them a detriment, making it a valid contract. Keep this nuance in mind, keep studying hard, and I'll see you in the next explainer.